Hey, so good afternoon, everyone. Thank you for joining us. I'm going to go ahead and I've already started the recording. Before we begin, I would like to acknowledge that the land on which we gather is a traditional territory of the Three Fires Confederacy of First Nations, which includes the Ojibwe, the Odawa, and the Potawatomi. The City of Windsor honors all First Nations, Inuit, and Métis peoples and their valuable past and present contributions to this land. We are pleased to have you all here to engage in an informative discussion with our panelists about the causes of wrongful convictions. We are honored to have our three speakers here with us, Professor David Tanovich, Ron Dalton, and Jessica Zita, to participate in this event. Professor Tanovich, as you may all know, is a law professor at the University of Windsor. He teaches and writes in the areas of criminal law, racial profiling, evidence, and legal ethics. Prior to joining the Faculty of Law, he was a law clerk to Chief Justice Lemaire and later appellate lawyer with Pinkowski and Lockyer. Professor Tanovich will begin the discussion speaking to the connection of race and wrongful convictions. Our next speaker is Ron Dalton. He's the co-president of Innocence Canada and also an exoneree. He was wrongfully convicted for the murder of his wife in 1989. It wasn't until 2000 that Mr. Dalton was acquitted. He will be sharing his story with us today. Last but not least, our final speaker is Jessica Zita. Jessica Zita is a defense lawyer and partner at Lockyer Zeta Z, located in Toronto, Ontario. She is an advocate for the wrongfully convicted and will share her experience working with the wrongfully convicted and the pursuit of achieving justice. Professor Tanovich, may you please begin?
Okay, thank you, Brandy. Thanks for organizing this event on behalf of Innocence Windsor, and thanks so much for Ron, for you agreeing to come and talk to us about your experiences, and Jessica about lawyering in this field. So I'm going to talk about the causes of wrongful conviction, some of the causes, the more common causes of wrongful convictions, and I want to link it specifically to the role that racism, and in particular anti-Indigenous and anti-Black bias, play in wrongful convictions. So one of the things we're starting to do better now is to actually track wrongful convictions. They've been doing this for much longer in the US, and the National Registry of Exonerations in the US is a wonderful resource in terms of data. It collects cases and it also tries to break it down in terms of the type of offense and some demographic factors as well. We're doing this in Canada. The Canadian Registry of Wrongful Convictions was launched earlier this summer. Some of you may have seen the press associated with this. The website is basically www.wrongfulconvictions.ca, and we're starting to slowly gather the data on wrongful convictions. So the first slide is the American data, and it gives you a sense of some of the more common causes of wrongful convictions: mistaken ID witnesses, perjury or false accusations, often the product of police misconduct, and I'll talk more about that. False confessions, false or misleading forensic evidence, which was certainly the case in Ron's wrongful conviction, and then official misconduct. Those are the more common identified causes of wrongful convictions. In Canada, here is some of the early data that we're starting to collect, and it tracks many of these same causes and has added some additional causes as well. And I'll talk a little bit more about that in a moment. The Department of Justice has studied wrongful convictions, and they have a website and a couple of reports, those that are interested in doing some research, and they too track some of the more common causes: tunnel vision, which I'll talk a little bit more about. And again, that was a big factor in Ron's case. Mistaken eyewitness evidence, false confessions, in custody informers, and forensic evidence and expert testimony. As I mentioned, in the US, they're tracking, as are we now, starting to track race and wrongful convictions, and the numbers collected in the US are absolutely staggering in terms of the disproportionality as it relates to race. You can see from the charts that disproportionately African Americans are wrongly convicted. And you can see by offense the discrepancy, and it is incredibly tragic and significant. For murder, sexual assault, robbery, drug crimes in particular, and other nonviolent crimes, Black make up the majority of exonerations. Canada, we're starting to track this data. Here are some that I've tracked over the years. It's not up to date. I haven't kept up, but the registry is starting to keep up. But these are a number of some of our more well-known cases of Indigenous wrongful convictions, from Donald Marshall, the case we all study in first year, dating back to 1983, all the way to Williams Mullins Johnson, to Richard Catchaway, and I'll talk a little bit about some of these cases. So we're seeing, similar trends in Canada in terms of disproportionate exonerations. In terms of African Canadians, again, we're only now beginning to track the data. A couple of, cases, Leighton Hayes case, case we study in evidence, case dealing with flawed identification, tunnel vision, and also, Crown misconduct. And O'Neill Blackett, who was one of the victims of Charles Smith, the rogue forensic pathologist. I'll talk more about that in a moment. Here's another tragic case, Tamara Broomfield, who was wrongly convicted of trafficking. And this stemmed from faulty forensic evidence. The mother risk lab, it's the sick kids in Toronto, CAS would send Indigenous and Black families overrepresented in CAS investigations, and also overrepresented in the unreliable results that were provided by the mother risk labs. And Tamara is one of the many victims of this faulty faulty forensic evidence. So let me talk a little bit about some of these causes in a little more detail and link them to some of the more well-known cases. So I want to talk a little bit about the investigative stage and tunnel vision. And let's start with the definition of tunnel vision. So here's a definition. Tunnel vision in the criminal justice context can be described as the tendency of participants in the system to focus on a particular theory of a case and to dismiss or undervalue evidence which contradicts that theory. This mental process leads to unconscious filtering in and of evidence that will build a case against a particular suspect, while ignoring or suppressing evidence respecting the same suspect that tends to point away from guilt. Confirmation bias is a powerful psychological process that causes an individual to unconsciously prefer information that supports a conclusion that they have already settled on, and to disregard or be overly skeptical about information that contradicts that conclusion. While tunnel vision narrows the focus of an investigation to a single target, confirmation bias leads investigators and prosecutors to filter in evidence supporting their theory and to ignore or undervalue evidence that suggests their theory might be incorrect. Confirmation bias causes people to seek, recall, and even interpret data in ways that support their prior beliefs. Pretty much every wrongful conviction we can think of, tunnel vision plays a role. It was one of the primary causes of Ron's wrongful conviction. The pathologist, as Ron will no doubt tell us, approached this case from immediately as a case of murder, as opposed to unknown or the possibility of an accident. And when he was doing his autopsy, just to give you some sense of his mindset, kept referring to the term assailant and the assailant marks. Again, he had already prejudged the case, didn't even think about the possibility that what he was using to make his determinations were the product of post-mortem injuries or injuries caused as they were trying to resuscitate. But no doubt Ron will talk more about that, so I'll leave that. So tunnel vision plays a significant role. And when we think about systemic racism and how we construct people based on race and the links between stereotyping and criminality, it shouldn't come as any surprise that with racism and racial profiling, tunnel vision becomes even more narrowed in cases involving Black and Indigenous suspects. Certainly that was the case in Donald Marshall's case. He was constructed right from day one by the police as a killer. And that led them to manufacture evidence and led them to not consider the exculpatory evidence that was out there. When we're thinking about tunnel vision and its effect, I think, and it's linked to systemic racism, it's, I think, helpful to think about the flip side. And here's a recent report done by the Office of the Independent Police Review Director in Ontario, looking at the problems with the Thunder Bay Police and the way they investigated Indigenous deaths. And we often talk about systemic racism, over-policing, under-policing. And this is the sort of the flip side. Tunnel vision, where you construct the death as non-suspicious. And that's exactly what happened here. The Thunder Bay Police, in investigating a number of deaths, too readily presumed accident in cases of Indigenous sudden deaths, relied upon evidence of drowning as virtually determinative that the deaths were accidental instead of intentional killings. And so I think this really helps us understand just how powerful tunnel vision is and how particularly powerful it is in cases involving Indigenous and Black participants. Racism and stereotyping can also lead to what's referred to as selective inattention. It's sort of another manifestation of tunnel vision, where there's a lack of critical attention to possible errors in the investigation, science, identification, interrogation, because those involved, whether it's police officers, whether it's experts, whether it's prosecutors, or even defense counsel, have constructed the individual as guilty, consistent with their racial background, or simply not deserving of care or any benefit of the doubt because of othering, seeing them as different and not deserving of the careful attention that we would expect of professionals. Professor Kent Roach, who has written a piece, and I've linked it here, on wrongful conviction of Indigenous individuals, makes this point in relation to 3 known Indigenous victims of Dr. Charles Smith's gross negligence. Professor Roach notes Dr. Smith was prepared to make moral judgments about mothers and fathers based on their lifestyles. For example, he thought women in troubled relationships or custody battles were more likely to kill their children. There's no specific evidence about Dr. Smith's attitudes towards Indigenous people, but he might have been suspicious of Indigenous people if he disagreed with their parenting practices and associated them with stereotypes about the abuse or neglect of children. And there were a number of Indigenous and Black victims involved in Charles Smith's case. Williams Mullins Johnson, wrongly convicted of killing his 4-year-old niece. And he spent 12 years in jail until Lockyer was able to expose the wrongful conviction and to expose Dr. Charles Smith's negligence. Tammy Markard, another Indigenous woman who was wrongly convicted and sentenced to life imprisonment, wrongly convicted of killing her 2-year-old son, again, as a result of Dr. Charles Smith's negligence. What about police misconduct, perjury, in the United States, they've been studying this, and they found that, again, the police are far more likely to lie, commit misconduct, plant evidence in cases involving Black individuals as compared to white individuals. This is a recent report which I've linked, and the authors noted, we also know of dozens of groups of innocent defendants who were deliberately framed by police officers who planted drugs on them. Almost all are Black or other racial or ethnic minorities. So far, we list 259 individual exonerees who were convicted of these fabricated drug crimes, primarily in 3 group exonerations. 87% of them are Black. And in Canada, we're starting to recognize cases and starting to document cases where the police are found to have lied by trial judges or misled the court. I've started to track these cases as well, and almost all of them involve Black or Indigenous suspects. False confessions, another cause of wrongful convictions, and one that is often difficult to explain to those not familiar with the criminal justice system. There's often the sort of natural reaction, how could somebody who's innocent falsely confess? Well, the sad reality is that interrogation room is so coercive that we know that many individuals end up falsely confessing. And the US data that we have show that African Americans are far more likely to falsely confess than whites, particularly when it comes to youthful suspects. 85% in the US of youthful false confessors who have been exonerated, are Black. How does this happen? How does race play a role? So here's an interesting article by Professor Najovsky, and they note, one possible explanation is that innocent Black suspects experience stereotyped threat and interrogations, and that this threat causes Black suspects to experience more arousal, self-regulatory efforts, and cognitive load compared to white suspects. These psychological mechanisms could lead innocent Black suspects to display more nonverbal behaviors associated with deception, and ironically increase the likelihood that police investigators perceive them as guilty. In response, investigators might engage in more coercive tactics and exert more pressure to confess on Black suspects than white suspects. This could increase the need to escape interrogation and the likelihood of doing so by confessing falsely more for Blacks than for whites. In Australia, they have special rules for Indigenous suspects. Concerns about vulnerability, concerns about culture, concerns about comprehension have led the courts to create special rules to regulate the police in the interrogation of Indigenous suspects. Cross-racial identifications and identification procedures, also a leading cause of wrongful convictions. I won't spend any more time here on this point, given the time. Here's some recent data, though, with respect to sexual assault exonerations and mistaken identifications. In 44% of all sexual assault exonerations with eyewitness misidentifications, Black men were convicted of raping white women, a racial combination that appears in less than 11% of sexual assaults in the United States. According to surveys of crime victims, about 70% of white sexual assault victims were attacked by white men, and only about 13% by Black men. But 52% of sexual assault exonerees with white female victims are Black, and 43% are white, which suggests that Black defendants convicted of raping white women are more than 6 times more likely to be innocent than white men convicted of raping women of their own race. False guilty pleas, which is closely linked to false confessions. We're learning more about that. And we know that Indigenous and Black accused are more likely to plead guilty. And in fact, our courts have begun to recognize this. And that's an important thing to study and for defense counsel to be particularly cautious of when representing Indigenous or Black clients. Richard Catchaway was put falsely to robbery and served 6 months for a crime he couldn't have committed because he was in custody at the time. Here's another Richard Brandt, another Indigenous man, falsely pled guilty in another one of Dr. Charles Smith's negligent investigations and reports. As I mentioned, our courts are beginning to recognize the concern about the high number, the disproportionate numbers of Indigenous accused who plead guilty. And if you look at some of the reasons, one of them is the concern about the lack of trust in the system. Justice Frank Akabuchi, who authored a report on First Nation representation on Ontario juries, looking into why there's so few Indigenous jurors. One of the things he found was Indigenous people often resolve their criminal charges by pleading guilty because they believe they will not receive a fair trial owing to racist attitudes prevalent in the justice system. This suggests that for Indigenous people, a conviction arising from a guilty plea may be less probative credibility because of the despair that they no doubt face when caught up in the criminal justice system. And that would equally apply to innocent individuals as well, pleading guilty, taking the Crown deal because of the lack of trust in the system. Last thing I want to talk about, and this relates to lawyers and lawyering, and that is the trial stage and the role of prosecutors, defense counsel, and trial judges, and the role they play in protecting against wrongful convictions in dealing with Indigenous and Black clients. Our Supreme Court of Canada has issued some strong statements about the need for our criminal justice system actors to do a better job in recognizing the existence of systemic racism, and in particular anti-Indigenous and anti-Black racism in the criminal justice system, and to take steps to ensure that their clients, and also with respect to the Crown, that complainants are protected from this and that trials don't become infected with racism. We have an incredibly rich now set of precedents, jurisprudence from the Supreme Court of Canada and from the Ontario Court of Appeal that all Crowns, defense counsel, and trial judges should be taking note of and incorporating in their arguments. I certainly take the position, and I've taken this position for many, many years, that in every case where defense counsel is representing an Indigenous or Black client, they should be bringing a challenge and raising systemic racism with respect to any piece of contested evidence. And as I said, the Supreme Court of Canada and the Ontario Court of Appeal in these cases has provided defense counsel with strong precedent to be making this argument, to use the rules of evidence, which are all about rules to regulate the trial, protect the trial from bias, including racial bias. And there are many, many opportunities now for lawyers to be taking advantage of this precedent and to protect their clients, particularly their Indigenous and Black clients, from wrongful convictions. All right, so that's just a very quick overview of some of the causes and how systemic racism exacerbates many of these causes.
Thank you, Professor Tanovich. I'm freezing. Am I freezing on everyone's end?
No, you're good.
Okay. Mr. Dalton, if you could please go next. Oh, I'll have to unmute you. You're muted.
You're on mute, Ron.
Should be much easier to hear me with the microphone on. I apologize for keeping everybody on a Friday afternoon, but I'm in Newfoundland right now, so I'm an hour and a half ahead of you, so I'm even later. This is a very big topic, a lot of material to try and cover. I'm not going to go into my case in a lot of detail. I will give you the Reader's Digest thumbnail sketch. 35 years ago in 1988, I was a bank manager in a small rural town in Newfoundland, Gander. We had about 10,000 people there. I was one of 4 bank managers. I was married with 3 young children. And in mid-August, my wife and I were sitting down to watch the national news About 11 o'clock in the evening, 11:30-ish, our three children were in bed sleeping. She was nibbling on some dry cereal just out of a small dessert dish, and she began to cough a little bit. And we were sitting next to each other on a little love seat in a den. I reached over and gave her a little tap on the back. She kind of waved my hand away. It didn't seem all that serious. I left the room we were in, gone for about 5 seconds, and came back with a little glass of water for her. And when I came back, she was on her knees in front of that love seat and becoming beet red in the face. So it seemed to be more serious at that time. I grabbed the spoon that she had in her dish and just checked to see if I could clear anything that might be in her mouth or in her throat. I also grabbed the telephone that was on the TV in that room. There was no 911 service in Newfoundland back in those days, so I grabbed the phone book that was sitting under the TV, called the local hospital, asked them to send an ambulance, and we were 3 or 4 minutes away from the hospital, so the ambulance wasn't very long getting there. They come in and brought in a stretcher. 2 ambulance attendants checked, told me that they had a pulse. They started administering oxygen, loaded her onto a stretcher, and at the same time they were wheeling her out of our house. A police officer showed up in the driveway just to see if there's anything that she could do. And I asked her just to stay in the driveway for a couple moments while I ran across the street, got my neighbor to come over, stay with the 3 children, ran back into the house, checked on the children, put my shoes on. I was running around in stocking feet at the time, and followed the ambulance down to the hospital. At that time, we got there shortly before midnight. And at that time, the emergency room at the hospital was under the charge of a student doctor conducting a locum or a vacation relief. He was an Irish medical student filling in for a couple of weeks in rural Newfoundland. And the poor chap was faced with a tough decision to make. He had a young woman, my wife was 31 years old, having some breathing difficulty. He could either A, attempt an intubation or putting a breathing tube into a live patient, which he had never done before. He had practiced on cadavers in medical school, or he could call in the hospital anesthesiologist, who would be the person most qualified and generally called upon in a small rural hospital to conduct that procedure. That would have taken a bit of time, so he proceeded and made probably the right choice to attempt the intubation himself. And I say attempt because unfortunately he put the breathing tube into her esophagus leading to her stomach rather than into her trachea leading to her lungs. And that tube gets sealed in place so that while they pumped air and oxygen into her for an hour and a quarter, none of it could escape her stomach and come up around the tube and find its way to her lungs. A couple of registered nurses who were in the emergency room with the doctor and other people trying to resuscitate my wife at the time brought to the doctor's attention that my wife's stomach was becoming distended. She was literally blowing her up like a balloon. So he stopped the resuscitation procedures twice, got his stethoscope out and said he could hear air passing through the tube, so everything was fine. And of course, it was not. So an hour and a quarter later, I was informed that they had been unable to revive my wife. And this is about 1:15 or so in the morning. So I went back to my house and stayed up all night trying to figure out how to tell 3 young children that their mother, who had been alive and well when they went to bed the evening before, had passed away during the night. Unbeknownst to me, then the following day, a pathologist, a hospital pathologist, not a forensically trained pathologist, but someone who worked in the lab in a children's hospital in St. John's, had been flown out to Gander to conduct the autopsy. And when he conducted the autopsy, he found this breathing tube in the wrong place, brought down the young medical student to show him that the tube was in the wrong place and explained the mistake to him that he had made the night before. But notwithstanding that, at the end of the autopsy, he concluded that this was a homicide and that this woman had been strangled by a single right hand, which is very specific and would become important years later because apparently overinterpretation is one of the hallmarks of an expert who doesn't really know what they're talking about. So the last thing that the hospital pathologist said at the conclusion of the autopsy about 11:30 at night, almost 24 hours after my wife had been taken to the hospital, was, "You better go talk to the husband." And the 2 or 3 police officers who were attending the autopsy did just that. They left the autopsy, came back to my house, asked me to attend the local RCMP detachment so they could give me the results of the autopsy. We had been looking for these all day. And when they got me to the RCMP detachment, they shuffled me into an interrogation room. And that's what they did for the next 6 hours or so. Before the sun came up, I was arrested and charged with second-degree murder. All pretty bewildering. Now, I had been up for a couple of days at that point, so I wasn't in very good shape to understand everything that was going on. I had no previous background, no involvement with the criminal justice system up to that point, so I was pretty naive in the ways of criminal justice, at least, going into all this. My first trial was conducted 15 months later. I did get bail after 10 days or so. I missed my wife's funeral, never got to attend with my 3 children while they were burying their mother, but I was granted bail for 15 months or so prior to my first trial. First trial lasted 6 weeks in Gander and came down to the opinion of the hospital pathologist that this was a homicide, and a board-certified forensic pathologist that we hired in Philadelphia and brought in to testify. But at the end of the trial, the local prosecutor looked around at the local jury and said, who are you going to believe, the local guy who did the autopsy or the hired gun from Philadelphia who looked at some pictures? Given that type of a stark choice, the jury went with the local guy. I was convicted, given an automatic life sentence, and sent off to federal penitentiary. There not being any federal institutions then or now in Newfoundland, I ended up in northern New Brunswick in a maximum security prison, and I spent the next 8.5 years there while I was struggling to get my appeal heard back in Newfoundland. I had paid my own way into prison, all the money I could raise, and cashing in pensions, selling my house, and family assistance. We spent over $100,000 in 1988, 89 money. And by the time I got to prison, I didn't have any money left. I had 3 young children back in the real world being raised by my sister and brother-in-law with the assistance of my parents and my wife's parents. They were all in the same small community in Prince Edward Island. But nobody had much money for lawyers. So it took me a while. The lawyer who had done my first trial and lost it had agreed to conduct the appeal. But back in those days, technology being what it was, we had to wait for transcripts to be typed up manually, and that was done by court clerks in their spare time when they weren't in court attending to other matters. So it was close to 2 years before we even got transcripts from the 6-week trial. It was another 1.5 years before the lawyer who had done my first trial sent me a quick little letter, a little 2-liner saying it's becoming, I think the quote was, it's becoming increasingly difficult to find the time to attend to your appeal, and you would be better served to find someone else. Not quite so easily done when you're sitting in a maximum security prison in northern New Brunswick. You're trying to find a member of the Newfoundland Bar 1,500 kilometers away who wants to work for little or nothing. You might get legal aid funding if you fight long enough. But I eventually did find a second lawyer to attend to the appeal. And this chap was a bit more senior than the first fellow. He did a lot of work, did a lot of research. He examined things from 6 ways from Sunday. He actually attended the local morgue at the medical school in St. John's at Memorial University, where someone let him wrap his hands around the neck of a cadaver just to see what that would look like, and did a lot of work, but he wasn't practical enough to actually file the factum or the legal argument for the appeal. So as the years go on, now I'm getting increasingly frustrated, of course. I'm writing to chief justices, and I went through 3 back in Newfoundland. I'm writing to the federal and provincial justice ministers, the premier, anybody I thought that could help expedite things, get things moving along. I challenged the Newfoundland and Labrador Court of Appeal at one point to exercise their equitable jurisdiction, go out and hire any qualified forensic pathologist that they could find to agree with the Crown's original hospital pathologist. And if the real experts said that this was a crime, then I was the right party and I would stay where I was. But if not, then we better have another trial and try and get it right. So as the years went on, I wasn't getting very far. 7 years in, I was eligible to apply for day parole, which I did, only to have the parole board turn me down, which I knew they would do. I had no release plan, and I was still in a maximum security prison, claiming to be innocent after being convicted. So I wasn't going anywhere, but I did want to build that extra piece of the record. So I went in, and the parole board, of course, told me that appeals couldn't be taking this long, and that the Newfoundland Bar would never stand for that sort of thing. And I said, thank you very much. I'll take your written decision and put it in my file. Following that, I wrote up my own appeal factum, and it was a pretty half-assed thing. It comprised some research I had done myself in the local law library, and some things that had been researched by that second lawyer and one of his assistants, but it was still a half-assed thing. Basically came down to go find some real experts to tell you what really happened here. When I filed that, though, it caught the attention of both the appeal court in Newfoundland and a young lawyer who had been working with my second lawyer as a junior, helping him out, because she had done some of this research. When she heard I had filed a factum, it was then a public document, she went down to the Court of Appeal and looked at it and was rather horrified to see that it was literally a half-assed thing, but it also contained some of the research that she had conducted. She was a little fearful for her own reputation. She didn't want to be seen as part of a very weak appeal when there might be legitimate grounds. And she contacted me in the maximum security prison, and we had a frank conversation. She said, our firm is literally breaking up at the moment, and this is one of the big issues. She said, your file is no longer in our office. The senior lawyer who has conduct of the matters has it at home with him. We can't get access to it. It doesn't appear that he's been doing some of the things, and I knew that at this point I would receive letters from him saying that he would be in Renouse at the prison to see me on Wednesday, February 14th or something, and I would get that a week later knowing that he wasn't going to show up. So I'm sitting around in a maximum security prison for 8.5 years by this point, and wondering which one of us is crazy, myself or the lawyer who's making all these promises. But I am collecting all those pieces of paper. It was the ex-banker in me and a little OCD, I guess, but everything that I kept and everything that I wrote manually, I wrote a second copy and kept for myself. And when I was working in the library, sometimes I could get some carbon paper and make some duplicates of things, but I amassed a fair-sized file. But when I filed my factum, the appeal court wrote me back and said, you need a lawyer to attend to this. And I said, yes, I have a lawyer who's just not attending to it. And they said, well, you should really push to get him going on this. I said, tell you what, you set a hearing date and you push the Crown to respond to my factum. And then we'll see if we can't get it before you guys at least to have a look at. So this young lawyer who had been doing some research for the senior lawyer working on my appeal called me, and she said, there is a gentleman who does a lot of appeal work in our building. He's not with our firm, but he's in the same building. She mentioned his name was Jerome Kennedy, and I knew his name by reputation because I was a jailhouse lawyer by this point, and I had seen some of the work that he had done. I've been writing letters for some of his clients back and forth. And she said, if you like, she said, I'll put the two of you in contact and you guys can take it from there. I said, well, I'm not getting very far the way things are at the moment. So she did that. Jerome and I spoke, and within 2 weeks, he had me transferred back from the maximum security prison in federal custody back to St. John's, to the local provincial facility where I could at least meet with him, work with him. And we spent the next 6 or 7 months going through grounds of appeal, primarily looking for fresh evidence, which mostly consisted of additional expert opinions, saying that the hospital pathologist didn't know his arse from his elbows, the way one of the authors of some of the textbooks put it, and finding, I think we ended up with 9 forensic pathologists who all disagreed with the Crown's original hospital pathologist. We also got a couple of experts in emergency room medicine in case we needed them to explain to the Court of Appeal and possibly to a jury later some of the mistakes that were made by the medical student on the night my wife was taken to the hospital. So eventually we filed all that. The Court of Appeal took 5.5 months to rule on it. I got an 82-page unanimous decision overturning my conviction. That was in May of 1998. So I had been 8.5 years inside of prison at that point, plus a year and a half that I was out on bail. So almost 10 years into this. My wife died in 1988. I was released on bail pending a retrial in May of 1998. The retrial began at the end of 99 and lasted 9 months. We had one little aborted try at redoing it in between, but the judge got sick a couple months in and we had to call that one off and start again. But during the retrial, the 9-month retrial from what had been a 6-month original trial, we did overkill, I suppose. We brought in several experts to say that the hospital pathologist had no idea what he was doing. He wasn't forensically trained, didn't have any experience, pointed out all the mistakes that he made. And we also brought in a couple of people to point out the mistakes that the medical student made. We brought the medical student back in, who was at that point at the retrial. Now we're going on to 11 years after the fact. At this point was actually teaching emergency medicine at Harvard. So he had learned from his mistakes and gone on to develop some expertise that he simply lacked back in 1988. The hospital pathologist merely dug his heels in and spent 5 days on the stand explaining that he thought he was right and he still thought he was right and everybody else had to be wrong if he was right. So the upshot of all that was in June of 2000, almost 12 years after my wife passed away, I was acquitted by the jury. The Crown had 30 days then to file a notice of appeal, which they declined to do on the 28th day. But to sum up those years, we had 3 children when my wife died. We had a 9-year-old son, a 6-year-old daughter, and an 18-month-old son. The 6-year-old daughter had just graduated kindergarten the year her mother died. And on the 20th of June, when the jury came back and acquitted me in the year 2000, this was in St. John's, Newfoundland, I spent a day and a half getting back to Prince Edward Island, where my daughter, who was now 18 years old and no longer 6 years old, was graduating high school that Monday evening. And I made her high school graduation by 3 or 4 hours. And for me and for her and for many people can kind of relate to what you missed during a 12-year absence from the real world and your family's life and your children in particular's lives. We can all imagine the things we did between ages of 6 and 12. And of course, I missed all that and they missed all that. And I was rather blessed. I was one of the few people serving a life sentence who knew where their children were, knew they were being well cared for. My sister and brother-in-law stood up and looked after them for 10 years when I wasn't around. They kept in touch. They visited the prisons. But it wasn't the same, of course. So when my conviction was finally overturned and the Crown folded their tent and went home, I looked around and I said, well, I know there's other people in the same situation. There was one in particular, a school teacher in Nova Scotia, Clayton Johnson, who had been convicted of first-degree murder and given a 25-year to life sentence on the strength of the same hospital pathologist's opinion. This guy was pretty malleable. If you put a result in front of him, he would find a way to back it up. And in Mr. Johnson's case, he went to Nova Scotia without conducting an autopsy, looked at some pictures and said, yes, this had to be a homicide, and they convicted him of it. So he and I had been comparing some notes before I left prison, so I knew that he at least was left behind and a victim of the same pathologist. But I knew there had to be others. I wasn't the only one. I heard of people like Donald Marshall Jr., and even before that, Stephen Truscott, 14-year-old child that we almost hung in 1959. It was a blight on the whole Canadian criminal justice system. So I had heard of some of these people, and of course I did a little bit of research. I looked around to see who was doing anything to help them, and there weren't that many. There were some innocence projects at the universities primarily, and there was this ragtag bunch of do-gooders in Toronto, James Lockyer and Winwar and a couple of other people who had worked on the Guy Paul Moran case and came to the same realization when they straightened his case out. They knew there had to be others. So they formed this little association to work on and look into cases. So I attended a number of their events If they were doing a conference, I would be there. If they were having an annual general meeting, I'd be there hanging around. I met some of these people. I met some of their clients. And eventually they asked me to sit on their board, which I've been doing for the last 16 or 17 years now. I've kind of lost track. I've been on the executive for the last 10 years, and I've been one of the co-presidents for the last 5 or 6 years. And I'm happy to say that we've got over 30 exonerations to our credit after 30 years of very hard work, including several of the Charles Smith cases. And I don't want to correct Professor Tanovic, but we no longer refer to him as doctor. And that's an important distinction for those of us who have lived through the wrongful conviction experience, because although most of these people never get punished or held accountable, in Smith's case, they did take his license to practice medicine, and he lost his job as a forensic pediatric pathologist. And then when you look at some of these indigenous cases that were up on the slides, there's 2 more as recently as July. Myself and Mr. Lockyer and Jerome Kennedy and some of our other employees were out in Winnipeg when 2 young Indigenous men, and I say young because they're my age, they were 17 and 18 back in 1984 or 1974, sorry, when they were convicted of a homicide. And they were not only acquitted, but the Chief Justice in Manitoba declared them innocent, which is something that very rarely happens in Canadian courts. And they were declared innocent the end of July, 50 years and 1 day after they had been arrested as 17 and 18-year-old young people. I was going to say children, not exactly children, but certainly very young at the time. So those are a couple more to add to that chart that starts with Donald Marshall and goes on and on. And there's no question that in the work that we do at Innocence Canada, we see the impact of race. And that was one of the big arguments we made in their cases. We were always looking for fresh evidence to overturn wrongful convictions. And that usually means something that wasn't argued at the trial or wasn't available at the trial and has become available since, and hence the name fresh evidence. And one of the big things we argued as fresh evidence was the systemic racism that was prevalent back in the mid-70s that led to their convictions. These were a couple of young Indigenous men fresh off of the reserve, didn't speak the English language very well. There was actually 4 of them arrested. 2 of them didn't speak English at all. The 2 who were recently declared innocent spoke some English, but they were arrested by the Winnipeg Police Service, taken into custody, put in 4 separate rooms, individually beaten, and 3 of the 4 signed a piece of paper with a 3-line confession on it, almost identical word for people that didn't speak the language. And the 4th guy, who refused to sign, was told he could leave once he signed this receipt to give back his articles of clothing and things that they had seized. So he signed a blank piece of paper and they typed his confession over it. At trial, these 2 individuals that were just declared innocent had good, solid alibis. One guy was with his grandparents 100 kilometers away. His trial counsel didn't even call the grandparents as alibi witnesses. The other chap was with his mother 35 or 40 kilometers away. They called his mother as a witness, but her English wasn't very good, and the judge told her to step down because nobody could understand what she was saying anyway. And that was kind of the extent. The judge rejected their allegations of physical abuse during their interrogations. He said that the Winnipeg Police Service wouldn't stand for that sort of thing, although all 4 of them independently gave statements to that effect. 2 of the police officers involved were subsequently charged for doing the very same thing to other officers. And they had the dubious distinction of all being prosecuted by the same prosecutor in Winnipeg that has the Canadian record as odious as it is, that for the most wrongful convictions. He was prosecutor in the Kyle Unger case and Frank Ostrowski case and these Anderson Woodhouse and the 2 other Woodhouses, and he's got, I think, 7 wrongful convictions to his discredit. He was very, very overzealous. Anyway, that's just a little touch on my sad story. I'd like to leave a little bit of time, so hopefully we can get a few questions in at the end. The upshot is that 35 years later, I'm doing much better these days. I'm in a semi-retirement, and I dabble in things for Innocence Canada that give me a chance to give back a little bit. But it's volunteer work, but I get the satisfaction of walking people out of prison that don't belong there sometimes, and that's very meaningful. I think we'll leave it at that for now.
Thank you, Mr. Dalton, for sharing your story with us. Jessica Zita, if you would like to go.
Thank you, Brandy, and thank you for having me here today. And last time I spoke, actually, I was trying to remember earlier. I had spoken with Ron at another conference, and it was actually earlier this year. And have to say, it's always difficult following up after him. His story is so compelling and beautiful and inspiring for all parts and players in the process. But one thing I want to mention was when I remember now when we last spoke together was either January, February of this year. And I remember that distinctly because it was just before the Miscarriages of Justice Act was announced, was made public. And I knew about it before it was made public because I work very closely with James Law here, and he was key, very key to the development of this act. And I recall that we were doing this talk with a lawyer from the CCRG, from working out of the minister's office. And there were some comments made about what the mystery behind this legislation, if it was ever going to come into play. And I remember just having to hold my breath and bite my lip and not make any sort of indications. But I remember looking at Ron and thinking he must know about this too. And I remember when James and then Justice Minister Lametti were on TV speaking about this legislation. It was just, it was a really beautiful day. I know James and many people, including Ron, have worked incredibly hard to get the legislation to where it is. I think it still needs to be subject to a third reading. But hopefully everything goes off without a hitch. And the introduction of that legislation would, I think what James said was that this was like the greatest day ever for the wrongfully convicted, because this could just be such a important tool in what is really already a really challenging, difficult, timely fight. And so on that note, I think the one thing I've taken, so I'm going to be talking about my experience working in this area, as Professor Tanovich had briefly stated earlier. And I want to kind of share some of my takeaways and really reduce, or really, I think it's very simple the way that I approach my work in this area, and I want to share why my experience has shown me that. And so the biggest takeaway I've had so far from working criminal defense is that I try to approach every case like it could be, like there's a potential for it to be a wrongful conviction. And that doesn't mean at all that they all are. But when taking on a case at the trial level, and what that means is from the point that the individual, the accused, has just been charged, I always consider the worst case scenario. And for me, that's being complicit in a wrongful conviction. My experience working alongside some wrongfully convicted individuals has taken two forms. The first is at the appellate level, where we try and overturn convictions at the Court of Appeal and at the Supreme Court of Canada. And the second would be behind the scenes working on ministerial review applications. I am working on and have worked on quite a few, but these applications, they take decades to materialize. So, it's hard to, I don't know if you'll research me and find my name attached to any of them, but that's just sort of how it works with these, and I'm going to explain why. the most important piece, there's two very important pieces of advice I'd like to give about how to approach every case you work on. And the first is to listen to your client. And the second, especially in the area of ministerial reviews, is to have patience. I always tell my clients that if you're going to do it right and you're going to ensure that the justice system is operating at the highest level, you cannot rush the process. Because when you rush the process, that's a guilty plea. That's as quick as you can be. But when you do it properly, you have to be prepared to fight every step of the way, and fighting takes time. It's always easy to say too that the system has failed. It's very easy to just say that, but it's hard. It's extremely hard to prove, and harder than that, it's often impossible to get the system itself, to agree that it failed. And these stories of success and overturning wrongful convictions are that they're the end result of someone screaming in a vacuum for years, decades, that this was something very bad has happened here. And for so long, probably no one listened, or no one who could help listened. And then the right people start to listen. But even when they say it, even when someone like James or Ron or Professor Tanovich says that this is a problem, that doesn't mean that all of a sudden it's resolved. That's just the beginning of hope opening up and the real work taking place. And that's it's a very, very difficult task. If you're able to get to the point that Ron and so many and a few others have gone to, you've likely waited years. I was actually going to state at this point the example of Anderson and Woodhouse, but Ron beat me to it. But it is worth repeating that this was the longest standing conviction that's been overturned in our country, 50 years. And what's sad about that is that there's probably people who are alive and in jail still that have been, or on parole still, that have been wrongfully convicted even longer. They just don't have the right, they don't have the right people in their corner. They've given up. Maybe they've just sort of resigned themselves to the reality. And that's the part of the work that I do that makes me the most sad. Obviously, the stories of people who have been wrongfully convicted and fought to be exonerated, those are the most beautiful stories. I'll say that forever, the most beautiful stories I've ever heard. But the stories that really, really get to me are the ones we don't know about and that we'll never know about, because these people gave up, they passed away too soon, they just continued to be abused in all sorts of ways. They abused themselves, and they had never had anyone to listen. And this is going to be a recurring theme in what I'm talking about today, how important it is to just stop and listen. Sorry. And the 50 years, right? The 50 years of having to fight to have their name, as an example, to be exonerated. Patience. You can't do that without patience. It's also very important to be fearless and to trust your instincts. It sounds so simple, but if something feels wrong, it likely is, regardless of how many people tell you otherwise. And I say this because it needs to, especially with the younger counsel, the system is not going to so easily capitulate to you. If you stand up and say that, the Crown is wrong in its assertion, the police conducted an improper examination, very rarely will anyone just say, okay, you're right. And that's where trusting your judgment really comes in, because so much of my job and so many others feels like we're running up against a concrete wall, just hoping that it budges. It doesn't always, but when it does, when you are able to move that boulder even just a little bit, it's worth everything, all the work, all the frustration that came before it. I think Professor Tanovich did a really good job explaining to you how it can all go wrong. And it often, if not always, starts at the police investigation phase. In Guy Palmeren's case, for example, it's a very well-known wrongful conviction case. He was zealously pursued as a suspect because he was, for really the only reason why was because he was described as the weird guy next door. This weird guy next door had 2 jury trials and 2 appeals. That's how long it took. I mean, it sounds like 4 altogether, but that's, one of the trials, the first trial, he was acquitted. The Crown appealed. They won. He went back. He had another jury trial. Jury trials are enormous resources of time and money. The second jury trial, he was convicted, and then an appeal had to happen. And after that, and by the time this was all said and done, it took years. It took a very long time. And what I always find, I mean, this story, like so many others, is fascinating when you parse through it. But in this particular case, the greatest showing of tunnel vision that Professor Tanovich was talking about, I think, would be the evidence of, or the testimony of the Crown, the trial Crown, who testified at the Morin inquiry. And so what happened after the wrongful, he went on appeal, was that there was an inquiry done. And an inquiry is an investigation or a hearing put together either by the federal government, provincial government, or both, where a public trial essentially is done to explore what went wrong in this case. And the idea is once that investigation is done, some judges, lawyers who've been appointed as commissioners of overseeing this inquiry, then make a recommendation that's to be followed by everyone on what we can do to prevent this from happening ever again. And as part of this inquiry, the trial Crown testified. And at this point, Guy Paul had been exonerated. But even so, post-exoneration, the trial Crown maintained at first that she still thought that he did it. Could you imagine? I mean, this man he had already been, I mean, he had been acquitted by a jury already, did the circle one more time, and finally was acquitted again, and she still publicly believed that he was the murderer. And, to her credit, I suppose, she testified over an afternoon, and then the next morning her testimony continued, and she changed her tune. She very quickly came back and resigned from that original position. And that's an interesting tale to tell, because so much of where police investigations go wrong is this tunnel vision idea, where there's an idea, there's intelligence, there's an information, and then that's just pursued to the exclusion of other real evidence that has come forward, either in the form of someone else's confession or information about a suspect that's not already the person of interest. And it's something that Kent Roach talks about, Professor Kent Roach. He often talks about intelligence versus evidence. And so often police investigations are pursued on the basis of intelligence, which it can often be synonymous with hunches or conjecture. I find when I question police officers in court, I quickly realize that the officers that are in court that I'm able to question, that they don't know what the impetus of their instruction is. They're just told to investigate this one person. They're following orders, and they don't actually know why they're investigating this person of interest. They just are. And so often it's terrifying when you dig into these, that the indicia that they are told to look for this person of interest is often skin color, very generic details, skin color. They drive a black car. they live in a certain area. Well, if you live in the city of Toronto with millions of people, that's a very easy square to peg. And that's why that's what you have to be so mindful of. What is real evidence and what is nothing more than rumor? And even if it's coming to you or if it's being given to you by someone who's deemed to be of authority, that should mean nothing. And the biggest obstacle that I see with younger lawyers and that I faced myself is the pressure that challenges your ability to fight. It's much easier to just ignore a problem when everyone else seems to be doing the same, when the entire system seems to be doing the same. But that's what makes panels like ours so important. In Ron's incredible story, for example, expert testimony was wrong. We're not taught in school that doctors get it wrong. But also in so many of these cases, that's exactly what's happened. You've heard of disgraced pathologist Charles Smith. I think it was a number, maybe more than a dozen wrongful convictions overturned because of his faulty, baseless conclusions. People who pled guilty because they saw no other option, because they wanted to just get out of jail because it was either that or a life sentence. And living, he was a pediatric pathologist, so it's one thing to, no, all life is valuable, but there's a certain sting to being labeled a baby killer. That's an awful title to live with, and living with that wrongfully when the doctor and your lawyers have told you that this is just how it is, for lack of a better phrase, it can really mess you up, and is not enviable in any stretch of the sense. But another example comes recently, actually, from the Court of Appeal of Quebec, from Quebec, and a former appellate judge, Jacques Delisle. His wife, he was retired, and his wife had killed herself with a shotgun. Mr. Delisle called the police when he found her. He called 911. The Crown's forensic pathologist ruled that it wasn't suicide. And since Jacques Delisle was the other person in the house at the time, he was the only suspect. He was found to be with exclusive opportunity, and so he was charged, and he ended up being convicted. And he tried to appeal that conviction at the Court of Appeal at his old workplace at the Court of Appeal of Quebec, and he lost. And then he tried to seek leave at the Supreme Court, and he was dismissed there. And after that point, James Lockyer got involved, and he was able to get a second opinion on the forensic evidence. And just like Ron's case, the forensic evidence showed that the way that the bullet had entered her head, it could only have been done by suicide, by someone who put the pistol to their head themselves. In Jacques Delisle's case, like, you've heard about people getting bail pending ministerial review. He did not. The whole system in Quebec and the Supreme Court of Canada believed that this man, this former appellate judge, that he killed his wife. And it took, even of course, racism is and systemic bias underlies so much of the tunnel vision that we've been talking about. But sometimes you have an expert that says something, and even if you're a former Court of Appeal judge in this country, that's going to be binding in court. And so again, another example of one not taking anything at face value, but also listening to your client. Because if no one listened to Mr. Delisle, if no one listened to Ron, if no one listened to Anderson and Woodhouse, no one would have ever discovered these horrible mistakes. This process is very human, and it's prone to human error. So the best tip I can give, I guess, if I could call it that, is that our job should be approached to all of you who are interested in doing this job, it should be approached as managing human error. You should be suspicious. You should always think critically. You should never accept anything at face value. And if your client or anyone coming to you adamantly expresses their innocence, you should listen above all else. Thank you.
Thank you, Ms. Vita. Our speakers have concluded now, so we have time for Q&A. I don't see that anyone submitted questions, but if anyone would like to ask a question now, just raise your hand. Caitlin, you could go ahead and answer or ask your question.
Hi, thank you so much to all the speakers today. This was an amazing panel. I just wanted to ask, going off of Jessica, you mentioned that the system is obviously inherently human. So how do we work alongside with, juries? Because they're human, but they don't have that legal background to, discern those different facts. So in what ways can we work with the jury to kind of combat that?
That's a very good question, and my response to that is that the jury trial might actually be the most human process in the criminal justice system. Part of why some lawyers tend to appreciate jury trials more is because you're speaking to laymen, people who aren't familiar with the jargon, and you are communicating to them in the most basic of ways, very human experiences. And I think at least, everyone's got a strategy when they're running a trial. But there's a certain element of humanity that doesn't really strike well in a judge alone trial that really resonates when you're speaking to a jury. Jurors get very, in my experiences, they get very involved in the process. They really listen to the words of counsel, and they really try to understand all sides of the story. And sometimes when you're doing a judge alone trial, things get lost in technicalities. Not that, it shouldn't matter with a good judge, but as a defense counsel, when I sometimes go to smaller towns, you have to imagine that Crown attorneys are before these judges all day, every day. And so, you can't help, as a judge who sees the same person all the time, you're gonna maybe, I don't want to say trust, but you're comfortable with them as opposed to the stranger defense lawyer coming out of, the big old ugly Toronto. That's when you're at a jury trial, jurors don't know, they shouldn't, they're vetted to not know any of you. So it's often in that sense, a very fair playing ground that you might not necessarily get at a judge alone trial. And I don't know if that effectively answers your question, but I think back to how I first started to answer this, the jury process is really, and it probably will always remain to be the most human part of at least a trial process. Sentencing is a different story, but I think when you have a story, when you go before a jury, you have a real human emotional story to tell that you think will communicate well to everyday people.
Sabrina, go ahead, please.
Hello. Firstly, thank you so much to all the speakers. The seminar was so informative. My question is for Jessica Zita. I was just wondering if you could share a little bit more about how you got into this line of work, working with wrongful convictions specifically, and what advice would you have to law students that are interested in this field?
Thank you. I started my practice, so I'm a 2017 call. And when I started working, I worked at a firm called Hicks Adams, and I was working under pretty well-known, well-respected appellate lawyer named Richard Lakowski. And it was with him that my experience first and foremost came from doing appeals with him. I also did jury trial or homicide trials with the named partner at the time, Chris Hicks. And at some point I had to change firms a couple years into it, and I got a job at Lockyer Campbell Posner, and I knew that I had started to work on wrongful convictions on my own accord at Hicks Adams. I was helping clients, like, just helping them file forms. So ministerial review is codified under the criminal code under section 696.1, and there's forms online that you can access for self-represented individuals who want to, who don't have access to a counsel, but want to file an application for ministerial review with the Minister of Justice. And so I was helping clients fill out those forms and helping them get in their trial files and all the materials you need to properly make those applications. So I was really just self-educating, and I didn't have anything in mind other than I didn't want to stop fighting for people. And when you're looking down the pipe of a life sentence, all you have is hope. And so from appeals, I got into paroles because I wanted to extend that hope. Once we lost the appeal, it's hard to win unless you're James. And and then with that, there's leave applications to the Supreme Court. And then after that, there's the last shot, if it's available to you, is the ministerial review applications. And so that was my push, just helping people and not taking no for an answer. When I started working at Lockyer Campbell Posner, I don't know how to say, with James just immediately took me under his wing, and it really just changed the course of my career. It wasn't, it's a lot of work, but it's very fulfilling and very rewarding. And just by working with him and with what I already knew, the experience doubled immeasurably. And the appeals that I was now working on were appeals of real, like, wrongful convictions after the trial that we're able to address at the appeal stage. And it just really enriched my experience. And through him, I got, you just happen to get access to all kinds of files of where you're seeing on the ground really poor police investigating, or prosecution offices taking really unreasonable positions. He seems to just be a magnet for these kinds of things. And I've just been very lucky, and I've been driven to try and get access to all of that and work on all of that with him. I really can't explain it other than just an ineffable desire to help and help people, like make sure there's no more Ron Daltons, which is a really heavy task, but for me, it's been a worthwhile pursuit.
Valeria, you can go next.
Thank you. Sorry, my camera doesn't work, but firstly, I would like to thank everybody. I really enjoyed this panel, and thank you, Brandy, for organizing it. I have a question to Mr. Dalton. Thank you for sharing your story. I was wondering if you were ever compensated for your time spent in prison, or how does it work in general in Canada? Do people have to sue the Crown, And also, I imagine it was very challenging to like get back to normal life after. And like, was it difficult for you to find a job after? And what were some challenges that you faced? Could you please talk a little bit about that? Thank you.
Quickly, Valeria, on the compensation issue, there is no provision in the Canadian Criminal Code to compensate people who have been wrongly convicted, because the code never contemplated that it would ever happen. So in my case and many other cases, we've had to resort to civil procedures. I spent 12 years from the time I was arrested until I was ultimately acquitted. On the criminal matter, I spent 7 more years fighting for compensation, and that included going through a public inquiry that was almost 3 years long, conducted by a former Chief Justice of the Supreme Court of Canada. So it's an uphill battle. I can tell you, as one of the co-presidents of Innocence Canada, one of the side benefits is I've met just about all of the wrongly convicted people in this country, some very fine people who've been through some tragic circumstances, and fewer than half of them have ever been compensated for what they went through. I happen to be in the fortunate half, and when governments apologize with their checkbooks, they generally swear you to secrecy and have non-disclosure agreements in place and stuff, so most of us are not even free to say how much we got. Never enough, but there has been some people getting compensated. But it's a very difficult process. It requires reform, and it's one of the things that Bill C-40, the new wrongful conviction bill, the David and Joyce Milgaard bill, as we refer to it, is hoping to address. We don't know. We haven't seen the details yet of that. In terms of my adjustment back to the real world, I was rather fortunate in a lot of ways. I was old by prison standards. I was 32 when my wife died, but the average age of prisoners tends to be a bit younger than that. But I also had a white collar background. I kind of had an idea how the world worked. So I knew when I was getting screwed over, at least. And some of the poor kids that grew up in the system and end up in there as 17, 18-year-olds really don't know when they're getting the wrong end of a deal or a procedure or policy. So I had a little bit of background, but I also had a family, and I had other supporters, but primarily my family. I had 3 children still out in the real world, I used to refer to it as, but that kept me focused on the other side of the prison walls. So I didn't tend to get wrapped up in some of the BS that goes on in a federal institution. You know, there's all kinds of people get wrapped up in the drugs and other things that go on in prisons, and I didn't. So when I came out, I was less damaged. I don't think any of us go through a process like that and come out completely unscathed, but I wasn't quite as damaged, but I had people to catch me on the way out. So the sad reality is that if you're guilty of a homicide and you're eventually released from prison on parole, there are some supports in place. You're gradually released. You go to a halfway house. You have a parole officer and some supports. If you're wrongly convicted and you get your conviction overturned, they open the door, say sorry about that, and you're on your way. So I was fortunate enough to have some good people around to catch and help me out along the way. I never went back to being a bank manager. They weren't looking to hire ex-cons by the time I got out, and even 10 or 12 years out of the society puts you behind in terms of technology and all kinds of other things. But I also want to try and spend some time with my family. I went back to raising my youngest child when I got out. My oldest 2 were 18 and 23. One guy was in university. My other daughter had just finished high school by the time I got out. My youngest guy was just going into junior high. So I got to pick up with him where I left off with the older guy. So I tried to balance it between some family time and supporting myself. I hung up a shingle, did some accounting and bookkeeping, but I also got involved in some small businesses and things that I used to do as a bank manager, I could now do on my own, with a desk in my basement sort of thing, and help people out along the way, as well as do a little bit of volunteering just for my own sanity, just to try and make a little bit of difference.
Thank you very much, and thank you so much for sharing your story again.
We have one more question from Olivia.
Hi, everyone, and thank you to all the speakers today for this panel. It was very enlightening, and thank you, Brandy, for organizing it. My question is a bit more general and is open to really anyone to answer. We talked in majority about wrongful convictions for the crime of murder. However, it is no doubt that wrongful convictions and more so wrongful confessions occur for smaller crimes, if you will, especially given a wrongful confession often dismisses a lot of the financial hardships, as was mentioned. So how, as a lawyer, do we target these types of wrongful confessions? And how do we encourage clients not to wrongfully confess, despite it may being easier, given there may not be a large penalty associated?
I was leaving that for Professor Tanovich to answer.
Oh, that seems fair.
So, I mean, there's, unfortunately, our Constitution doesn't offer the protections that that individuals really need. In Canada, for example, there's not a right to have a lawyer present during during a police interrogation, and that's really too bad. There have been a number of cases. The Supreme Court of Canada's had a number of opportunities. We don't have that, and so all you really get as an individual is a call to a lawyer and a lawyer's advice to stay quiet. But it's almost impossible to stay quiet in an interrogation room. It's so coercive. You are so isolated, and the police are so skilled at securing a confession and creating an environment to get you to confess that it is really impossible. And so for lawyers, and this comes back to one of the earlier questions too. For lawyers, when we talked about juries and how do we ensure that we protect the reasoning process of jurors to protect against wrongful convictions, and it comes back to what I said earlier about using the law of evidence and the rules, and to be making arguments, in every case, to try to get the evidence excluded, because that really is the best protection against wrongful convictions once you're at the trial. And in the absence of the ability to secure exculpatory evidence in an effort to raise a reasonable doubt, all you're really left with is trying to get the evidence excluded. One of the things we need to do better in Canada, again, the case law is not very good, is with respect to expert evidence, and using expert evidence to try to inform the jury about the causes of false confessions and what the markers are of particular false confession in the particular case. And so that's something that we need to do a better job of in terms of trying to make arguments for the admissibility of expert evidence. Failing that, again, it's about lawyers being creative and taking what we do have in terms of thinking about the social context evidence, which includes the causes of false confessions, and really making strong arguments in particular cases, either to get the evidence excluded or ensuring that the trial judge is in a position to be able to explain to the jury what some of the causes are of false confessions, and then why in the particular case there are some indicia of that. As I said, it really does come down to using and learning about the rules of evidence, because they offer when we're at the trial stage, and the best protection against wrongful convictions.
Thank you, Professor Tanovich. I know that was quite a broad question.
I believe that is all our questions. I just have a quick one if people don't mind staying behind a little. For Ron, my question is, I know that Innocence Canada is just focusing on homicide cases at the moment. Do you think, or do you know if there will be a time that will extend to other cases of convictions?
I can't predict the future, but I suspect we'll never have the resources to look at anything other than the most serious of cases. We had a case review committee meeting a week ago, and we have, I think, 117 cases. 53 of them are actively being worked on. The other 62 are on a wait list that's going to run us 2 to 3 years before we even get an opportunity to get to them. Again, the legislation that's been proposed in Bill C-40 proposes to look at a whole range of miscarriages of justice, as the term will be. And we have to figure out how that's going to happen. Will the most serious ones that are on our wait list be done first before a lesser crime, if you will, a break and enter is done? So for the time being, I always encourage people, particularly students, to question everything, which gets back to what Jessica says, because the fact of the matter is the truth will stand up to questioning. But if it's not true, then it pays to be the contrarian and go in and question everything that you can. You don't have to worry. If we had more contrarians questioning things, we wouldn't have as many wrongful convictions as we've had.
Thank you. So that's the conclusion of our event. I'd just like to thank our speakers for participating and taking the time. So everybody is free to go. Thank you for attending and listening in.
Thanks, Brandy, and thanks, Ron. Very nice to meet you. Jessica, thank you. Very nice to meet you. And hopefully we'll cross paths in the foreseeable future. Thanks, everyone.
Have a great weekend.
Thanks, everyone.